Preamble of the Constitution. So, American Constitution was the first as a preamble. Begin with a preamble, and including India followed the practice. The term preamble is referred to the introduction or preface. It consists summary or essence of the Constitution, and a Palkiwala, an eminent jurist, called the preamble as the identity card of the Constitution. And a Palkiwala, he told this is the identity card. The people of India, having solemnly resolved the Constitution of India into a sovereign, socialist, secular, democratic republic, justice, social, economical, and political liberty of thought, expression, belief, faith, and worship, equal status, opportunity, and the promote among all, fraternity, assuring the dignity of individual and unity and integrity. In our Constitution Assembly, this 26th day of the November 1949, do hereby adopt, enact, and give to ourselves the Constitution. Preamble reveal for the ingredient of component, source of the authority of the Constitution. The preamble states that the Constitution derives the authority from the people of India. So authority comes from the people of India. Nature of the Indian state. It declared India to be of a sovereign, socialist, secular, democratic republic. Objectives of the Constitution states here justice, liberty, equality, and fraternity. Date of the adoption of Constitution was the 26th November 1949. It is for the adoption. Certain keywords are sovereign, socialist, secular, democratic republic, justice, liberty, equality, and the fraternity. What is meaning of sovereign? So sovereign imply the India is neither a dependence nor dominion of any other nation, but independent state. So there is no authority about it, and it is the free to conduct its own affair. Though the 1949 Indian declared the constitution of her full membership of Commonwealth, the extra constitutional declaration does not affect the Indian sovereignty. So UNO also is no way constitute the sovereignty. Socialist was added in the 42 Amendment 1976 of DPSP. In other words, what was hitherto implied in the Constitution has now been made. Moreover, Congress party itself adopted resolution of the socialist pattern of the society, notably democratic socialism and not a communist socialism. So, production and the distribution and abolition of the private property, mixed economy, and matrix and Gandhian. It is a blend of Marx and Gandhian lining having towards the Gandhian socialism, and that was the Gandhian socialism. And the new economic policy, liberalization, privatization was come. Secular was the 42 Amendment 1976, Supreme Court 1974 of the secular state. There can be constitution maker wanted to establish a secular state, so guaranteed the Article 25 to 28 freedom of the religion, and the Indian Constitution embodied the concept of secularism. Democratic means Democratic Party as stipulated in the preamble. Democracy is of two types, direct and indirect. Direct democracy, the people exercise their power directly as a Switzerland. There are four devices: referendum, initiative, recall, and plebiscite. Indirect democracy, on the other hand, the representatives elected by the people and exercise the supreme power and thus carry on the government and make the law. This type of democracy, also known as the representative democracy, parliamentary and presidential. The Indian Constitution provides the representative parliamentary democracy under which the executive is responsible to the legislature for all its policy. Universal adult franchise of the periodic election, rule of law, independent judiciary, and the absence of discrimination ground other manifestation of the democratic character. The term democratic is used the preamble broader sense, only political democracy but also social and economical. This dimension was stated Dr. Ambedkar, the conducting speech of the Constitutional Assembly November 25. Political democracy cannot be lost unless this lie with the social democracy. So equality, fraternity, and the liberty is also provided, and union of trinity is there. Now the equality cannot be divorced from liberty, nor can liberty from equality be divorced. Without equality, liberty would product the supremacy of the few of many. Equality without liberty would kill the individual initiative. Supreme Court observed 1997, the Constitution advises to establish the egalitarian society, and that was the Bharat and Republic. Republic is what the polity can be classified into two categories, monarch and republic. In the monarch, head of the state is the queen or king. hereditary, and the Britain is republic. On the other hand, head of the state is always elected directly, indirectly, fixed period, that is in USA. Therefore, the term republic of the preamble indicate that India's elected head called the president. He elected indirectly for the fixed period of 5 years. The republic also means two more things: one, vesting of the political sovereignty in the people, single individual, and the absence of any privileges classes. Justice is given the preamble: social, economical, and political justice. Social justice denotes the equal treatment for the all, and it means all the absence of privileges being extended to a particular section of society, improvement of the backward classes. Economical justice is no discrimination of the economical factors and inequality, wealth, income, and property. The combination of social justice and economical justice, that was known as a distributive justice. Political justice is that was the equal political right. Idea of the justice was known as the justice and resolution. Liberty is means the absence of restraint from the activity of individual and same, providing the opportunity for the development of the personality. Preamble secured the all citizen of the Indian liberty, thought, expression, belief, faith, and worship. Liberty, as elaborated, the preamble is very essential for the successful functioning of the democratic system. And liberty conceived by the preamble, the idea of liberty, equality, and fraternity is known as the French Revolution. Equality is means the absence of special privileges, and the preamble ensure all the citizens of India equality of the status and opportunity. So equality is a civic and political and economical equality, equality before law, prohibition of the discrimination ground of the religious, race, caste, and sex, equal opportunities, abolition of untouchability and title. There are two provisions of the Constitution that seeks to achieve political equality. One, no person is to be declared ineligible for inclusion of electoral roll, religion, race, caste, and sex. So, to election to the Lok Sabha and the State Assembly, there was a adult franchise, and the directive principle of state policy secured the men and women rights and the adequate means of livelihood, equal pay for the equal work. Fraternity is the brotherhood. The Constitution promotes the feeling of fraternity, of single citizenship. Fundamental duties 51A promote the harmony and spirit of common brotherhood. The preamble declared the fraternity has to the assured the dignity of the individual and the unity and integrity. According to the Munshi, a member of the drafting committee of the Constituent Assembly, the phrase dignity of the individual signifies the Constitution not only ensure material betterment but democratic setup. So DPSP as a fundamental right, and DPSP which ensure the dignity of the individual, protect the dignity of the women's and dignity of the women's and men. Okay. Now next is significance of the preamble. Preamble embodied the basic philosophy of the fundamental values, political, moral, religious. As a constitution base, it contained the grand noble vision of the constitution, reflect the dreams and aspiration of the fundamental father of the constitution. Sir Aladi Krishna Ramaiah Iyer was member of the Constituent Assembly, played significant role. Preamble is express what we thought or dreamed to so long. According to the Munshi, a member of the drafting committee of the Constituent Assembly, preamble is the horoscope. Pandit Thakur Das, another member of the Constituent Assembly, summing up the importance of the preamble. And the preamble is the most precious part of the Constitution. It is the soul of the Constitution and key of the Constitution for the Constitution. Sir Baker was the distinguished English political scientist, paid the glowing tribute to the political wisdom. He described the preamble as a keynote and the Constitution. He was moved by the text of the preamble as a opening for the popular principle of socialist and political theory. Preamble as a constitution, that was the Verubai Union case. The Supreme Court said that preamble show the general purpose behind several provisions of the constitution. Key of the makers of the constitution further where term used in any article ambiguous or capable of more than one meaning. Some assistance and interpretation may be taken. And now there is a Keshwan and Bharti case of Supreme Court rejected the earlier opinion and held preamble as a part of Constitution. It observed that preamble of the extreme importance and constitute should be read interpreted the light of the noble vision. Now the other part of the Constitution was preamble was also known as the Constituent Assembly Constitution are already enacted. Preamble is conformity with the Constitution adopted the Constitution Assembly. Preamble President concerned the question that preamble start part of the Constitution. So the preamble neither source of power of the legislation nor a prohibition upon the power. Na to that is not a source, not a prohibition. It is non-justifiable and its provision are non-enforceable. You can't go to the court and non-justifiable also. So the question is whether a preamble can be amended. That was Article 368. Keshwan and Bharti case, it was urged the preamble cannot be amended. It is not part of the Constitution. The Constitution contained the amending power 368 cannot be used or destroy, damage the basic element of the Constitution. The Supreme Court, however, held that preamble is part of the Constitution, and the court stated that opinion tendered by the Berubari Union in this regard, and that a preamble can be amended subject to the conditions no amendment is done the basic feature. In other words, the court held that basic element of the fundamental feature of the Constitution is contained. The preamble cannot be altered or amended. The preamble has been amended only once so far. 42 Constitution Amendment added the socialist secular integrity, Union and its territory. Union Article 1 of the Constitution that was described the federation of the state. This provision deal with the two things, the name and the country and the polity. There is no unanimity in the Constituent Assembly with regard to name of the country. Some members suggested the traditional name Bharat and advocated name that was India. India, that is Bharat. Secondly, the country described the union although the Constitution is a federal. According to Ambedkar, the phrase union of the state has preferred the federation of the state, and that was given by the Ambedkar. Okay, the federation is a union because it is indestructible. So, union is indestructible, and the country is the integral whole of the divided into different states. Territories, union territories, and territories may be acquired by the government. So, there was a name and the union territory, their territorial extent. 29 states and 7 UTs are there. And in the same manner, the special provision was state Maharashtra, Gujarat, Nagaland, Assam, and general provision relating to the state. Further, the 5th and 6th schedule separate provision with respect to the scheduled caste and scheduled tribe. And territory of India is wider for the Union of India because the latter include only state, while the former include not only the state but also the territory and the territorial that was acquired the government of India. The state are member of the federal system, shares a distribution of powers, and the union territory and the acquired territories are also there. Being a sovereign state, India can acquire the foreign territories also. So international law, cession, occupations are there. So what is the cessation? Cession means following treaty and purchase and gift. Next one is Article 2, that is empowering the Parliament admit into Union of India, establish new state on the such term of condition think fit. Article 2 grant two powers: the power to admit into the Union of India new states, power to establish new states. The first refer to the administered of the state which is already existent, but the second refer to the establishment of the state which word cannot be existence. Notably, Article 2 relate to the admission of the establishment of the new state that cannot part of the union of the state. Article 3 on the other hand relate to the formation of change of the existing state or Union of India. So 3 deal with the internal readjustment of the state. That was internal readjustment. Parliament power of the reorganization of the state. So Article 3 form new state by the separation of territory, increase the area, diminish the area, alter the boundaries and alter the name. So Article 3 lay down the two conditions regard bill contemporary the above changes with the prior recommendation of President, and before the recommending the bill the President has to refer the same to the state legislature. Further power of the Parliament to form the new state, including the power to form a new state or union territory by the uniting one or more part. President is there, not a view of the state legislation, but now Parliament may form the new state, alter the boundaries existing state. In other words, Parliament has draw the political map of the India according to territorial integrity or the constitute not guaranteed as a constitution. Therefore, India is a rightly described as the indestructible union and destructible state. So there we can destructible states are there, but we can't destroy the center. And American federal government cannot form a state or alter the borders without the consent of the state concerned, but we can do this. So that is, the USA is described as an indestructible union of the indestructible states. So states are also indestructible in the American system. Now, moreover, the Constitution Article 4 itself declared that law made by the admission or establishments of the new states under Article 2 and formation of the new state, alteration area and the boundaries Article 3 are not to be considered an amendment of Constitution. This means that such law can be passed a simple majority. Does the power of Parliament diminish of the area and including also the power to cede Indian territory to a foreign territory? So this question came up with the examination before Supreme Court. Central government to part of the territory known as the Berubari case. So now there was the Indian territory can be ceded the foreign state only by the amending the constitution. If one state wanted to cede, then they need to take some amendments in the constitution. Consequently, 9th constitutional amendment was enacted, transfer of the Pakistan की जो territory, that was again according to the 9th amendment. On the other hand, Supreme Court in 1969 ruled that settlement of the boundary dispute between India and another country does not require a constitutional amendment. So, जो boundary settlement है, that is not needed any amendment. It can be done executive actions and does not involve the cessation of the territory. Under Article 100, that was 2015, Bangladesh, in pursuance of the agreement and its protocol between the government of India and the Bangladesh. Under this deal, India transferred the enclave of Bangladesh. 51 enclave was transferred. Okay. So India and Bangladesh have a common land boundaries approximately 4096 km. The India-East Pakistan land boundary was determined by the Radcliffe Award. Dispute arose of the some provision of Radcliffe Award which was sought resolved through the Bhage Award. And Nehru-Noon Agreement was in 1958. However, issue relating to the division of the Berubari Union challenged before the Supreme Court comply with the opinion, and due to the continuous litigation and other political development at the time, the Constitution of 9 Amendment could not be notified. Now, 16 May 1974, agreement between the India and Bangladesh concerning the demarcation of the land boundaries, and now there was the undemarcated boundaries, the territory in the adverse possession, and the exchange of enclave were identified, resolved the signing the protocol. Land boundary agreement was India and Bangladesh in 1974. Assam, Meghalaya, Tripura and West Bengal is included. Integration of the princely state. So that was a paramountcy of the British Crown. The Indian Independence Act was there, created two independent separate dominion, India and the Pakistan, and gave these options are princely state joining either India or Pakistan remaining independent. So 552 princely state situated within the geographical boundaries, and 549 joined the India. Remaining 3, Hyderabad, Junagadh and Kashmir, refused to join the India. However, course of time they were also integrated with the India. And referendum that was in Junagadh, Kashmir was because of the instrument of accession, and police action was taken in the Hyderabad. In 1950, the constitution contained a fourfold classification of the state, that was part A, B, C, D, and that was in 1950. So now what? 29 part A was stated the comprising governor of the provinces. Part B state considered 9 erstwhile. Part C was erstwhile chief commissionaries was there, and part D was the Andaman and Nicobar that was included. Dar Commission and JVP Commission. So integration of princely state with the rest of the India purely advocated has been demand from the different region. Linguistic basis, reorganization of the state on the linguistic basis, and Government of India adopted the linguistic provision and the commission there to examine the feasibility, and the commission submitted 1948 में report दी गई basis of the administrative conveniences. So this created much resentment and led to the appointments of the linguistic provinces. Jawaharlal Nehru, Vallabhbhai Patel and Pattabhi Sitaramaiah was there. Now next was 1953, Government of India was forced to create a first linguistic state known the Andhra state. So Andhra was the first linguistic state, And the followed prolonged popular agitation, death of the Potti Sriramulu, a congressperson after the 56-day hunger. Fazal Ali Commission, Andhra Pradesh intensified the demand for the region creation of the state of linguistic basis. This forced the Government of India appointment 3 members of the State Reorganization Commission. Fazal Ali. So, K.M. Panikar Kunjru, it submitted report and the broadly accepted language basis reorganization of the state. One language, one state. It is was the unity of the India should be regarded as the primary consideration. Preservation of the strengthening the unity and linguistic and cultural homogeneity. Financial, economical consideration and the planning and promotion of welfare. So commission suggested abolition of the fourfold classification. 16 state and 3 central administrative territory were constituted that time. Government of India accepted recommendation of the minor modification, State Reorganization Act and 7 amendment of Constitution. So that was now there was a 14 state and 6 UTs in November 1, 1956. सो स्टेट के जो नाम हैं आंध्रा, असम, बिहार, बॉम्बे, जम्मू कश्मीर, केरला, मध्य प्रदेश, मद्रास, मैसूर, उड़ीसा, पंजाब, राजस्थान, उत्तर प्रदेश एंड वेस्ट बंगाल. यूटीज़ के नाम हैं अंडमान निकोबार, दिल्ली, हिमाचल प्रदेश, लक्षद्वीप, मणिपुर एंड त्रिपुरा. द स्टेट रीऑर्गेनाइजेशन एक्ट एस्टेब्लिश by the state of Kerala merging the Travancore. Cochin state was the Malabar districts and it was merged the Telugu speaking area of Hyderabad. Okay, now it merged the Madhya Pradesh. ये पूरा मर्जर हुआ. न्यू स्टेट एंड द यूनियन टेरिटरी महाराष्ट्र और गुजरात को 1960 में. दादरा नगर हवेली in the 1954. गोवा दमन दीव in the which amendment there was a 12th amendment was there. So गोवा दमन दीव 1987 में ये बन गया. पुदुचेरी दैट वाज 1954 में माहे करेकाल यनमन पुदुचेरी. नागालैंड 1963 दैट वाज नागा हिल्स एंड नाउ हरियाणा चंडीगढ़ 1966. मणिपुर त्रिपुरा एंड द मेघालय इट वाज 1972. सिक्किम इन 1947. 5 कॉन्स्टिट्यूशन अमेंडमेंट से सिक्किम को बनाया गया 1974 में. एंड आर्टिकल 2A ऑफ द न्यू शेड्यूल वाज एडेड for the 10th schedule of term of the constitution. And now there was a Mizoram and Arunachal Pradesh and Goa 24, 25, 23. Telangana was 29 state of the Indian Union Territory. Changed the name. The name of this some states and Union Territory have also been changed and the Union Provinces was first state to have a new name. So Uttar Pradesh in 1950, Madras renamed Tamil Nadu, Karnataka in the same and Lakshadweep in the 92. Union Territory of Delhi that was designed National Capital Territory of the Delhi 69 amendment. Uttarakhand का नाम सेम रहा. So this was all about the states. Now next is about the fundamental right. We will discuss the fundamental